You are listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your host is Denise, your experienced law teacher sharing knowledge on various areas of law, including contract, torts, the English legal system, and criminal law. Understand the law better and learn the skills you need to get the grades you need.
Hi, welcome to LawWithDenise.net. I am Denise. In this episode, we're exploring the following three questions. What is an invitation to treat? What is the difference between a bilateral contract and a unilateral contract? And why do the courts normally say that advertisements for bilateral contracts are invitations to treat, but say that advertisements for unilateral contracts are offers? So let's start with question number one. What is an invitation to treat? Now, as law students, you know that in order for acceptance, for agreement to be reached, there needs to be a clear, specific offer put forward by party A, and this offer needs to be accepted by party B. Once that acceptance is made, we have an agreement, and providing all the other elements necessary for contract formation are present, a contract is formed. You will or you should already be familiar with the idea or the fact that party B cannot accept an invitation to treat. So that is why it's very important for you to be able to distinguish between an invitation to treat and an offer. Now, an offer is a clear, specific statement that is put forward by party A to party B. And when party A puts forward this statement or proposal, he intends to be bound by it. But an invitation to treat is quite different. An invitation to treat will be a statement or a suggestion made by party A. And when party A makes a statement or proposal, he does not intend to be bound by it. In fact, he is inviting party B to further bargain or to make negotiations. So if we go back to Gibson and Manchester City Council, we remember that the statement made by the council was as follows. We may be prepared to sell you this property at £2,180. The court said this was not an offer. This was an invitation to treat. The court explained that this sounded or seemed like a stage in the negotiations between the parties. And if Mr. Gibson wanted to purchase the property, he would have needed to put forward an offer, and then the council would have needed to accept it. But this unclear, unspecific statement that they may be prepared to sell him the property at $2,180 was not a statement that was clear and specific, that sounded like the council intended to be bound by it. It sounded more like they intended for Mr. Gibson to put forward further bargaining or negotiations. Hence, it was an invitation to treat. In addition to these types of contracts in which parties are involved in negotiations and bargaining, there are some specific instances in contract law where the courts have told us this is not an offer, this is an invitation to treat, and you need to be able to identify them. One of them is with regard to goods on display in shop windows. For goods on display in shop windows, the courts say that these are normally invitations to treat. And usually we cite Fisher and Bell when making this statement. Additionally, goods on display for self-service are also invitations to treat, and our case for that is Pharmaceutical Society and Boots. Lastly, goods that are advertised in bilateral contracts are normally invitations to treat. Now, goods advertised for bilateral contracts, I'm speaking specifically or more generally with regard to goods being advertised in newspapers and magazines. And one of our cases that we cite is Partridge and Crittenden. However, the courts have told us that usually goods that are advertised for that advertisements for unilateral contracts are generally offers. And one of the cases you can cite is Carlisle and Carbolic Smokeball. So let's now move on to the second question, which is what is the difference between a unilateral contract and a bilateral contract? Now, a unilateral contract is one in which only one party has an obligation. So with Carlisle and Carbolic Smokeball, the company put out an advertisement, and the advertisement said that if anyone who used their smoke ball and followed the instructions they gave were to get the flu, they would reward that person with £100. Mrs. Carlisle used the product, followed the instructions, and she still got the flu. So Mrs. Carlisle wanted her £100, but Carlisle and Carbolic Smokeball refused to give her the £100. And this is why they ended up in court. They argued that they had not in fact made an offer because it was not possible to make an offer to the public at large. The court said, yes, you can make an offer to the public at large. But more specifically for our purposes now, in terms of understanding what a unilateral contract was, let's look at who had an obligation in that contract. Did Mrs. Carlisle have an obligation? No, she didn't have to use a smoke ball. She did not have to, but definitely Carbolic Smokeball had an obligation, and their obligation was to provide her with £100 if she had used the product as they instructed and still got the flu. So that's one party with an obligation, a unilateral contract. Now, a bilateral contract is very different. With a bilateral contract, two or more parties have an obligation. So if, for example, I want to sell you this phone at £50, we both have obligations if you decide you want to purchase this phone for £50. I would have to give you the phone and you would have to provide me with £50. I have to give you the phone and you have to give me the £50 because we're now in a contract which requires two people to take action, which obligates two people to do two different things. So this is different to a unilateral contract. And then our third question then is, why does the court take the approach it does with regard to unilateral contracts and bilateral contracts when speaking about invitations to treat and offers? And the reason behind that is because with bilateral contracts, the courts understand that when party A puts his or her advert out, they expect or they anticipate further bargaining and negotiation. So if I put my phone out for ad in a newspaper or magazine or on Gumtree, according to the courts, most of the time with such advertisement, party A expects or will, it won't be abnormal if party A receives some further bargaining or negotiation from someone who is interested in a product. So this is an invitation to treat normally. But if we look at unilateral contracts, and these are very similar to the Carlisle smokeball scenarios, sometimes they are just rewards, right? So it could be a reward put out saying, okay, I've lost my dog Sally for £50. If you return my dog Sally to me, I'll give you £50. Now, the courts say that generally with those types of contracts, when party A puts out that advert, you are not anticipating any further bargaining. And you are, in fact, thinking that you'll be bound by your words. That's why you put out an ad saying, if you find my dog, I'll give it to you for £50. So one, you do not expect further bargaining, and two, you expect that you'll be bound by your words. Hence, the adverts for unilateral contracts are normally offers. But the adverts for bilateral contracts, the courts say, are usually invitations to treat. I hope that was helpful, and see you soon. Bye.
You've been listening to LawWithDenise.net, the best law podcast for A-level, undergraduate, GDL, and master's law students. Your experienced law teacher sharing knowledge on various areas of law, including contract, tort, the English legal system, and criminal law. If you like the content, please remember to like, share, and comment. Thank you.